One of the things people worry most about when separating is the cost of getting divorced. The cost of going to family court can be very high. Separating spouses want to know which spouse will pay the legal and other fees. This episode of the Ontario Family Law Podcast explains who pays for family court and how to get your spouse to pay. I'm John Schuman, a certified specialist in family law in Ontario. I'm also a mediator, arbitrator, and collaborative lawyer. This podcast is a companion to my book, Guide to the Basics of Ontario Family Law, which is available on the iBookstore, Amazon, Kobo, and at fine bookstores. When people mention court costs, they are speaking about two types of things. First, the cost for filing documents with the court or other fees that someone has to pay directly to the court to have the court proceed with a specific step. Second, the fees charged by lawyers, accountants, process servers, and other professionals in relation to the litigation. Not surprisingly, the fees charged by professionals are usually much higher than the fees charged by the courts. Ontario's almost completely pay for the family court system through their taxes. The changes to the Divorce Act, effective July 1, 2020, recognize that avoiding court and the associated fees can also significantly reduce the professional fees. So parties should consider using mediation, arbitration, collaborative practice, or the Ontario government's child support online recalculation service where appropriate. When parties stay in court, it is important for them to understand who will pay the costs associated and why. Most court fees are associated with either getting a divorce or asking the court to assist with property division. Either the Superior Court of Justice or the Superior Court of Justice Family Court deals with those matters, depending on in which municipality the court proceedings take place. There are fees for filing an application asking for a divorce or asking for an order respecting property, filing an answer to those demands. Check out the previous episode explaining the steps in family court for a bigger explanation. Fees for scheduling a trial or getting a divorce order. Getting a summons to a witness for trial. For a divorce certificate, which is necessary to remarry. And the fees for photocopies. People also have to pay for transcripts of court proceedings, but those fees, which can be many thousands of dollars, are owed to the court reporters, not to the court. There are no court fees for court proceedings in the Ontario Court of Justice or for cases in relation to only child support, spousal support, or parenting. With respect to the payment of the actual court fees, the party who takes the step pays the fees. This means, for example, the spouse who files his or her answer to the claims made by his or her ex pays the cost of filing that document with the court. While court fees can amount to several thousands of dollars, they are not usually the fees that people talk about when they talk about the cost of family court. Most of the costs of going to family court are associated with the professional fees, especially the cost of lawyers and, where necessary, accountants. Initially, parties pay their own professional fees associated with family court litigation. Where a party qualifies for legal aid, he or she may not have to cover the cost of legal fees associated with parenting or support matters. Legal Aid Ontario does not assist with the legal fees associated with obtaining a divorce order or for property matters, essentially the same matters for which the Superior Court of Justice charges fees. Legal Aid Ontario is also not supposed to pay for the fees associated with a person taking an unreasonable position. Also, to get legal aid, a person must have very little income, such little income that the person is living in poverty. Since legal fees can be a significant portion of the cost of getting divorced or dealing with another matter in family court, it is helpful to do things to keep those fees low. I gave some important tips to keep your legal fees down and save money in a previous episode. Note that hiring a lawyer with a lower hourly rate will not necessarily save you money. You need a lawyer who is competent to handle the issues in your case. More complex or difficult cases require more senior lawyers with higher hourly rates to get the results that you want. Many people find that when they pay less for a lawyer, they end up paying far more than they saved due to a bad settlement or court order. It can be useful to at least consult with a senior family law lawyer to know where you should end up and how to get there. It can also be helpful to consider hiring a good lawyer either for unbundled services or as a family law coach, which can give you as a party more control over fees, because using that approach, you take more responsibility for handling the litigation, but also has some help in doing so. However, the question of who pays for family court does not end there. Ontario has a loser pays court system. That means that the unsuccessful party in court pays some or all of the lawyer, accountant, and other professional fees of the winning party. So while each party may have to pay those fees as they go along, at the end of a trial, motion, or appeal, the judge may order that the losing party reimburse the winning party for some of those fees. On a quick side note, it is possible to have one separated spouse pay the other separated spouse's legal fees in advance. Judges do that when one spouse has all the money and is holding on to it, and the other spouse needs access to some funds to protect his or her rights in court. In family court, judges do not just assess who won, as that can sometimes be difficult to determine. They also look at which party behaved more reasonably, whether the party has acted in bad faith, and, most importantly, any formal offers to settle made by the parties. Rule 1814 of the Family Law Rules states that when a party gets a result that was as good or better for them as a previous formal offer that the party has properly made, the other party should pay all or substantially all of the legal fees. Put another way, a party who beats an offer to settle in court can expect the other party to pay the legal fees for both sides, including reimbursing for any fees already incurred. The idea behind this is simple. If one spouse had accepted the offer from the other spouse when it was a good offer, he or she would not only have come out better, but save both spouses the time, aggravation, and cost of continuing in family court. When everyone would have been better off if a party had taken an offer, the party who decided to keep on playing in family court can expect to fully pay the cost of everyone else who was dragged along. It is very important for everyone involved in family court to make an offer that he or she can beat as early on as possible. That way the question of who pays the cost of family court will be your ex. A former spouse may end up paying all of the professional fees associated with the family court process, even when those legal fees are hundreds of thousands of dollars. It remains important to act reasonably. A party who acts in bad faith always pays the other side's legal fees and other fees, regardless of the outcome. It is very important to get good legal advice and to take reasonable positions before the court and make good offers to settle to get reimbursed for legal fees. Having to pay the legal fees of both sides can bankrupt or at least cause serious financial harm to the person who has to pay them. There is one caveat to that. Legal fees related to support can be enforced by the Family Responsibility Office and survive bankruptcy. Other fees can be very difficult or impossible to collect if the other spouse has no money, even when that person with no money lost. For those cases, when considering taking steps in family court, it is especially important to consider the associated costs when the other side will never be able to reimburse those costs. It may be best to try to settle, as the professional fees will be more than any benefit of fighting it out in court. Court is definitely not for everyone. In fact, most people rightfully seek to avoid it. Separated spouses and parents can save a lot of money by staying out of court. So who pays then? Most couples negotiate a separation agreement with the help of lawyers, and then have the lawyers write up the agreement. When that happens, each side usually pays his or her own legal fees, unless they negotiate something different. In those cases where parties reach a fair agreement, each spouse usually ends up with enough money to pay his or her legal fees without getting into financial trouble. When the parties go to mediation, most often each side pays for his or her own lawyer and half the cost of the mediator. This gives both sides some commitment to resolve their matters at mediation, at a much lower cost than going to court. Although where the parties both view mediation as worthwhile, but one spouse doesn't have the funds available, they can agree to share the cost of the mediation differently. Most arbitrators expect each side to pay an equal amount towards the arbitrator's fees, unless they have agreed to special arrangements. However, most arbitrators also adopt the cost rules that are in the family law rules, or at least ones that are very similar. So what arbitration offers to settle are very important, and the loser pays. In arbitration, it is common for the arbitrator to order that the unsuccessful party pay the arbitration fees, including reimbursing the other side for fees already paid. It remains important to act reasonably, listen to a lawyer, and make good offers to keep the cost of any separation, divorce, or other family law matter low. Parties cannot be divorced except by court order. A divorce is only necessary to allow the spouses to remarry, so even after settling everything outside of court, someone has to pay the court fees to get the divorce. Spouses often include who will pay for the cost of the divorce in their settlement. Speaking to a lawyer about your situation can help you determine what path will work best for you. Good family lawyers will help you find the lowest cost solution to the challenges you face in separation or divorce. And when those low-cost solutions are not available, a good family lawyer will give you advice to try to get your ex to pay all the costs of going to family court. For a more thorough explanation of the Ontario family law concepts in this episode, and more guidance in the Ontario family court process and all the alternatives to court, including some tips for how best to succeed in your separation or divorce, get a copy of my book, Guide to the Basics of Ontario Family Law. You can find it at the iBookstore, on Amazon, and for Kobo. You can also get a lot more family law information on www.schumanlaw.ca. Not only are there hundreds of pages of family law information and links, but there are links to where to get my book and links to reach my office to meet with either me or one of my colleagues. Because it is always best to get a family lawyer who can give you expert advice that is specific to your situation. In addition to my website, keep up to date on family law and children's law issues by liking my Facebook page, following me on Twitter at @SchumanFamilyLaw, and finding me on LinkedIn. Of course, please also subscribe to my YouTube channel and the audio versions of the Ontario Family Law podcast on iTunes, SoundCloud, and at www.schumanlaw.ca. Thanks for participating in this podcast. We will get together again soon.